Okay.
Good afternoon, everybody. Thank you so much for taking the time to join us today. I am Lillian Morvay, the founder of the Independent Broker-Dealer Consortium, and I'm so pleased to bring our panel to you today. We're going to talk about 10 best compliance tips for broker-dealers and registered investment advisors. So with me today, I have Derek Anderson, a partner with Wingett, Spadafora, and Schwartzberg. Derek is in Hawaii, as you can tell by his background. Just kidding. Derek is in Boulder, Colorado. Next, we've got Amir Tajuddin. Amir is the founding member and partner of the TTE, sorry about that, Amir Law Group, and he hails out of Portland, Oregon. Ryan Smith is a partner with Practice out of their DC office. So gentlemen, we are going to start the conversation today with some of the top 10 best compliance tips for broker dealers and registered investment advisors. And we're going to start with every client is a potential claimant. Ryan, why don't you start out?
Thank you, Lillian. Thank you for having me. And it's a pleasure to be here with Amir and Derek. Basically, any client that's on your book, that's someone you may face off in a customer complaint or a client arbitration, even if your firm did nothing wrong. An example, years ago when I was a defense lawyer at a large wirehouse, I had a case and the wirehouse did nothing wrong. As it turns out, it was a feuding soon-to-be ex-husband and a feuding soon-to-be ex-wife arguing over, and what turned out to be nominally a theft of monies complaint turned out to be, no, this was a larger domestic relations issue. So, I mean, even something as simple as that embroiled my client at that time in this mess. So it just underscores the fact that if they're on your books, you act as if you see them in an adversarial proceeding at some point in time down the line.
Yeah, Lillian, if I could just kind of dovetail on what Ryan just said. This is counterintuitive because so much of this business is relationship driven. You start relationships off on a good foot. You don't expect them to take a turn 2 years down the road. We're going to talk a little bit later about the importance of documentation, but there are conversations that take place prior to the relationship being memorialized with a new account form. There are conversations that take place at the time that recommendations are made. And you never think in terms of, well, this couple or this individual, this client may not be happy with me 2 years down the road, and it may be important, for my defense of a potential case 2 years down the road, that some notes of conversations that took place at the time I first met these folks is important. And it's important to start training your mind early on in this business, that unfortunately it's a litigious business. There is a whole group of ambulance chasers on the plaintiff side that chase cases aggressively, and they do a very good job generating business. And it's important to have your ducks lined up in the unfortunate event 2, 3, 4, 5 years down the road, you're defending a case that hinges on conversations that took place early on.
So, Amir, let me ask you this question. Have you ever had a client talk to you about firing one of their investor clients?
Well, I've had multiple instances, as have probably any defense attorney handling FINRA cases, in which the client, namely the broker, has said, this client was always a pain in the you-know-what. And we met multiple times and we explained and he still didn't get it. And I just never could get through to him or her. And in certain sales conferences that I've attended, where we are presenting to the sales force, not the compliance, legal, or supervisory folks, we've given sort of the general advice that it's not a bad idea at the end of every year to audit your own client base, and this may not be in your financial best interest, but to weed out the 2 or 3 clients that are challenging, difficult, obstinate, refuse to listen to you, have unrealistic expectations, because it's at least very possible, if not likely, that when and if you are sued, it's going to be one of those 3 or 4 that are the ones filing the claim against you. You know who your good clients are, and you know who your bad clients are. And it's typically, not always, but it is often the bad clients are the ones that are the ones filing claims.
So I suspect that there is going to be a very detailed transition of that client out of your firm. How do you handle it to make sure that you've done it correctly and then that's not going to come back to haunt you? Ryan?
Well, that's difficult. I mean, I think unfortunately, I think Amir's advice is spot on. I can't tell you how many cases I had in my wirehouse days where, you know, the complaint or the arbitration claim comes in and the advisor says, yeah, I knew it, that person's a problem coming in the door. And those are the types of clients that equate any sort of losses with misconduct, and that's an unfortunate thing. So getting them off the book, that's very delicate, because if you keep it in the family, if you keep it in house, you're just shifting, you know, a potential problem from your book to one of your colleagues' books.
Mhm.
So I wish I had a magic answer for that. I guess the stock lawyer answer, it depends, comes into play, simply because it does depend. If it's a client who, you know, there's a particularly high risk of it escalating by dint of just being asked to go, you know, find another home for his or her assets, you might handle that differently from someone who's, you know, maybe it's less adversarial, that's more friendly. There's still, you know, a client that you don't want in your book, but you know that you can probably transition that client off in a certainly different manner than the first type of client I described.
But it really comes down to documentation and probably giving that individual a good lead, 30, 60, 90-day lead to find a new home. Would you agree?
Well, I at a minimum, because especially if they've got, you know, they've got to find a new home for, even if they do self-directed somewhere else, they got to open the account there. They got everything set up. They got to ACAT the positions over. If they're going to go find another advisor, it probably even take longer, simply because they're going to want to vet that particular individual. And that's assuming, of course, they're doing so with a smile on their face and not upset that you've asked them to, you know, take their business elsewhere, which no one likes being, you know, rejected. And I don't care what the context is. And this would certainly qualify as being rejected in some form.
Agree with that. So we're going to talk a little bit about know your product. I think that all of my panelists here will agree that although alternative product sales comprise maybe 10, 15% of a broker-dealer or registered investment advisor's book of business, the claims that are generated from those transactions are what, 50, 75% of the arbitrations that you gentlemen see regularly? At least, right?
At least.
At
Yeah.
least. So we can talk about this topic for an hour, but we are going to give you some salient tips on know your product and how to protect yourself. Derek, what do you think?
So the first point I would stress to firms is making sure that there is adequate training involved in-house that's available to your sales force. So these days, it's actually, it's gotten a lot easier that a lot of registered representatives could basically take courses explaining products, take tests at the end of those courses to make sure that, at least in the moment, they appreciate and understand the features of a particular product, the risks of a particular product. You know, over time, I'd say over the last, let's call it 15 years, we've seen a ton of alternative investment litigation, you know, that started after 2008. And that's not always been the case. So, you know, if I'm defending a case and my registered rep cannot explain to an arbitration panel the risks, the features of a particular investment, if he or she does not sound like the professor in the room explaining the product to the panel, it's going to be extraordinarily difficult to convince a panel that the rep understood the product and explained it adequately to the claimant. Because what we always see when a product fails is that the claimant is going to argue to a panel, I did not understand this product. It wasn't explained to me by my registered rep. It was impossible for me to understand and or appreciate the risks, which were not disclosed, notwithstanding the information that's on these checklists that I signed and or initialed. And so the rep has to understand the product, and if he or she does not, it's just fatal to defending these cases, and it will ultimately inform settlement discussions, settlement decisions, whether or not what we pay to settle a case is what we view to be fair or unfair. So that's probably the most important part of this is understanding the product and making sure that there's a mechanism in place so that your sales force understands it as well.
So Amir, we know that when you get in front of the arbitrators, those claimants don't recall anything. They don't understand the product. They may have signed a document, but they didn't know what they were signing and they relied on their advisor or the rep. How do you counter that? And what do you recommend that every registered rep and financial advisor do with respect to documentation and paperwork to support the sale of that product?
I think Derek's point is well taken. First, the broker should understand the product. In terms of documentation, what we invariably hear in every case is these are pro forma documents. The prospectus defense is not really one that the panel should rely on. These are extraordinarily complicated products. And no rational average retail client would understand the complexities associated with that product. And the best way to refute that is from a documentary perspective. I'm limiting this to documents. Obviously, you want a good rep and a good understanding of the product. But with respect to documents on the actual suitability side of it, you want to make sure that your records are not internally inconsistent. So if somebody opens an account in 2014 and has a moderate risk disclosure, and that's never been updated, and they have 5 or 6 alternative products, that's going to be hard to explain. So if you, from the new account forms should spell out what the investment objectives are, and they should be updated regularly. Ideally, every time a new complex or alternative product is sold, you're gathering new contemporaneous information as to that investor's suitability profile. Their net worth, if it's changed, that should be reflected. You know, a lot of our cases concern concentration limits. So if you see a jump from a net worth of, let's say, hypothetically 1 million to 3 million, and that's not really driven by anything, there's no backup documentation for that, the insinuation or the implication will be that you ginned up that number in order to get the broker-dealer to approve the sale of additional alternative investments. So keep your house in order with respect to suitability information. Make sure it's updated, make sure it's contemporaneous, make sure it's consistent. With respect to disclosures and suitability information concerning complex, alternative, non-correlated products, in an ideal world, and with the understanding that this is creating more paperwork and additional review, it would be nonetheless very helpful that you have a fact sheet or a 2-page document that memorializes the specific risks of that investment, that those are initialed by the client, that they are representing that they understand salient features like illiquidity. If something is tied to the real estate market, that there's real estate risk. If it's a complex, structured note, that it's opaque and difficult to decipher. They are doing this because they are looking for a higher yield, that this is non-correlated, that there's a reason we're going into non-correlated assets, and that you understand that we are ideally allocating only a relatively small portion of your net worth to these complex products, these alternative products, and there's a reason we're doing that. And you can do that in 2 or 3 pages. And when the argument is then presented, well, the prospectus was 100 pages. Who reads that? You go, well, you didn't, we're not asking you to, yeah, you acknowledge you read it, but in addition to that, what we have here is a 2-page document, ladies and gentlemen of the arbitration panel, that is written in plain English, that's easy to understand, and that contains all of the risks and all of the suitability information. And Mr. and Mrs. Jones, who are now feigning ignorance about this, signed it. They initialed it. They told us this is what they wanted. It's pretty hard to refute that if you're sitting in an arbitration room and saying we didn't know what we were buying.
There seems to be a bit of controversy over whether or not it's legal, appropriate, and whether you should record this conversation with your clients. Ryan, why don't you give me your thoughts on that?
Before I do that, I'm happy to do so. I'll underscore everything that Derek and Amir just offered and add this context as well. It's more than just arbitration litigation that we're talking about here. There's also a regulatory component as well. By way of background, I'm a former and current CCO. I'm also ex-FINRA lawyer, and every single regulatory notice I've read about new products in the last X number of years, FINRA's made a point of saying that they expect the sales force to be educated on what they're selling. So I agree. This helps the defense counsel when you're sitting across the table from an arbitration panel, put on the best case possible. But it's also going to be very helpful if you have to account for your actions in front of your friend in the neighborhood regulator, because they're going to expect it as well. So back to your question about recording, that's a tricky wicket, because there's a couple of things to consider. One of which is that not every state allows you to do so with one party. Some states are two-party consent. That's one of the joys of the federal system that we have. We have federal law, we also have state laws, and this falls strictly in the state law context. So if you're contemplating that, certainly, get the advice of counsel as to whether or not you can. Now, as to whether or not you should, that's a whole other story as well, because we're talking about disclosures, and we're talking about a lot of things that get put in front of the client at the point of sale. And there's that delicate balance. I'm not ignorant to the fact that, it could be off-putting, especially if the client thinks they're being, quote unquote, Mirandized or, being recorded. So, I would encourage every firm who can, is watching this either live or on demand, is consider, okay, what's appropriate for their business? What is the appropriate level of documentation or memorialization that they want to achieve given their product line? I think that answering the should question is probably more important than answering the could question at this point.
Mind if I just touch on that issue as well? So Lillian, in addition to whether or not you should, some consideration has got to be given to, if you do, then it's discoverable, right? So the thought would be that if I record this conversation, maybe it undermines a position that the claimant takes 2, 3, 4 years down the road. But on the other hand, I'm sitting on some recordings right now in a case that are not necessarily helpful, and that actually reinforce the position that the claimant's taking. And, I've got an obligation to produce those. So it's there are pluses and minuses to both sides of that question, because oftentimes the conversation is not what may be recollected, again, several years down the road.
Yeah, I was going to ask whether or not any of you have had recording issues in arbitration or even in mediation. So thank you for that, Derek.
And so, Amir, I got a question for you. And you talked earlier about keeping your suitability house in order. So I'm sure everyone on this call has seen cases where the suitability information is different across documents, right? So let's say new account application is filled out, net worth is 500 grand. 5 years later, some alternatives are being bought, net worth is now $1 million. So, it's jumped up. There may be other pieces of paper where there are inconsistencies. Would you mind just touching on, at the supervisory level, how should a firm follow up with that? Because you're going to need to explain it down the road. But from my perspective, making sure it's addressed is probably fundamental to defending a case as well.
I think, the problem seems to arise in, again, the theme of today's discussion seems to be all roads lead to alternatives, maybe because it's like those are the cases we're seeing. And in the case of alternatives, certainly, and I think Derek and Ryan would agree with this, almost everybody we represent has some form of concentration limits or aspirational concentration limits on alternatives. And when a client is buying more and more alternatives, and we've seen fact patterns where, let's say, the early tranche of alternatives turned out well, then a GBB pops up, or a hospitality, or now a GWG, and you've got this cataclysmic alleged failure involving one product. All of the other alternatives suddenly become at issue, even though some of them went full cycle. There are no net out-of-pocket losses associated with those. But the history of selling alternatives becomes front and center, with the argument being you're chasing commissions. And here you are looking at new account forms, you as a Piava attorney saying, well, when they opened the account, the net worth was X, and here they are when they're selling their sixth and seventh alternative. Either the net worth has not changed, or it has changed in very suspicious ways. It's increased. From a supervisory perspective, I think it's a very, very good idea for supervisors to inform their registered reps and the Series 7 licensed folks that as a best practice, it is a good idea to just generally update the new Know Your Customer information on an annual basis. You know, there may be innocuous explanations for an increase in net worth. That some of that could be the market performance, an inheritance, a bonus, or whatever it is. Or, you know, if you don't have that explanation and you don't have it updated in the form of either a wellness letter, you know, which, you know, here's your updated form, tell us if it's incorrect. But ideally, every year, you know, if you're talking to your clients, update it and make sure you, at the point of sale, have an updated suitability profile that correlates to what is being recommended by way of a complex or alternative product. You should have something in the file other than a new account form that relates back to when the relationship was established or the accounts were originally opened.
You know, and I don't think we can emphasize enough document, 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 and that leads us into our next really important tip. And, you know, one of the questions that I have for you all is, when you see an application that the majority information is pre-populated by a program that is put in place, is that something that you want to see when you are defending in arbitration, you know, applications and documents, pre-populated information in forms? How do you feel about that?
I think, you know, I think in today's sort of day and age, pre-populated seems to be more common than it ever was. I think, you know, that's just the reality of how people are completing forms. You know, back in the day, back when we all started doing this, it was handwritten and it was scribbled, and, you know, then it became a question of who wrote it on the paper. Is this your writing? Is this the broker's writing? And, you know, most claimants, a lot of claimants, I'd say at least 50% in an actual arbitration say, he just gave it to me and he told me to sign it. I've become more neutral on that. My preference or my directive is just make sure it's accurate. Make sure it's absolutely accurate. I don't care if your assistant pre-populated it or they filled it out. What I want is to make sure it's accurate. Don't fib, don't exaggerate. Don't make sure that inconsistencies are explained away. You know, most people who complete new account forms check growth in income, moderate, and yet years later are buying something that is incompatible with those investment objectives. So what is it that you understood about this client? You know, what I really liked is a database form or a note that says, when I met Mr. Jones back in 2015, he told me he had been investing for 30 years. He owns 3 houses. He has, you know, rental income. He has this, he has that. I want to see documentation that you know who this client is. You learn things about them. You learn that they have real estate that is producing income, that they have experience in other types of investments, that they have, you know, whatever it is that makes them unique from somebody else. Who completes the forms, I become more neutral on.
All right.
Yeah, and Lillian, quite frankly, you know, having a singular source of truth about a particular client will address part of what we were just talking about in terms of the inconsistency and new, you know, demographic and other data across accounts. Now, it may not necessarily address whether or not that source of truth is current. So I agree with Amir. Having hygiene exercises, as I call it, is certainly a worthwhile practice, not only just for client accounts, but any one of a number of disclosures you have. Like, for example, for one client, I'd say a hygiene exercise on U4. Just go through it with a fine-tooth comb, just make sure everything is what you expect it to be. And I think that's a worthwhile practice. And I realize, you know, I say this recognizing that in this current regulatory climate, it's difficult enough as a compliance and legal staff to keep up with the new initiatives that are coming down at breakneck speed. So clearly, at least from where I sit, the undercurrent behind all of this is taking a risk-based approach to these measures. I mean, for example, you know, clearly a client who's investing in what we call alts, might pose more risk, certainly from a litigation perspective, than a client who's, simply investing in, garden variety ETFs or mutual funds. So maybe in your hygiene exercise, the cadence for clients to get updated on those products is certainly, or who invest in those products rather, is certainly less frequent than the ones who are, in the more esoteric products. So all these things are going to, be put into the calculus, because even FINRA would concede you can't do everything all at once. You have to take a risk-based approach to all this. I think this is certainly one of those areas where it proved to be very valuable for a firm.
So let me ask you this, when should negative response letters be used, and are they effective?
So Lynn, I'll take that. And I think that they are effective. I actually have a few clients who send them out yearly and essentially memorialize with their investors, their clients, that, hey, this is the information that we have on file for you currently. This is what we understand your net worth to be. This is what we understand your investment objectives, your risk tolerance to be. If any of this is inconsistent with your understanding of what you've informed us, let us know, right? And it's probably a fairly easy piece of paper to generate internally and to send out. But again, with the types of cases that all of us are seeing and have been seeing for years now, oftentimes the argument you hear from the claimant is, look, on this document, whether or not it's the suitability form for a particular alternative investment or on the new account app, the rep filled this out. I signed it, didn't pay attention to it. Maybe the rep filled it out after I signed it, but that information is not true. And so therefore, this particular investment is unsuitable because it's inconsistent with my financial information. And so if you do have that, we'll call it a negative consent letter, if you do have that in the file, and if that's going out on a yearly basis, it completely undermines that position. So again, this gets back to that first slide we had, where every client is a potential claimant. As a firm, if you are doing certain things to CYA, it's probably a good idea. And this is one of those things that's fairly easy to generate and is quite handy if we're defending a case down the road.
I would love to hear some examples of documentation failures that have just sunk in arbitration. Who's got a good example?
Well, I have to look at the participant list to see who we're going to be talking about. Yeah, I think we've all got examples. We have one where it was a family, a mom and two children, adult children. The mom was a retired school teacher and a widow. And on the one side of the documents, you had emails between the rep and the mother in which it's established that she has a limited net worth, that she's a widow, that she's living on these retirement assets, which at the time were concentrated in annuities. And then a series of recommendations for products that we would all agree are very risky. And the way that the rep got around the supervisory and compliance limitations on recommending this was by opening the accounts as joint accounts with the adult children, such that the household net worth all of a sudden became the controlling net worth for whether or not these would be approved. So there was no way to reconcile email communications, which evidenced that he understood these were her assets, not her children's assets, with the fact that he was recommending investments that just did not comport with that investment objective for that individual. There's no way that the emails on the one hand were consistent with the recommendations on the other. And you can argue, as we did, that these were joint accounts and that the son and the daughter opened them with her. But everybody acknowledged, as did he, that he understood that these were her assets. So to circumvent sort of the firm's guidelines and supervisory review, he set up the accounts in a way that was improper. And there's no way that on my best day, I could have made a persuasive argument as to the suitability of those investments. There was just too many inconsistencies.
Yeah, Lillian, I think.
Yeah, and I just confirmed that client is not in the participant list. So we're good to go.
That doesn't sound familiar to anybody.
Right.
Yeah, sorry, Mary. No, I think you're quite, I mean, documents, I mean, all of us have been there. I mean, and probably everybody who's can hear my voice right now has been there where it's a factor no matter what sort of issue you have. I've had claimant case where I represent the claimant where I got a great discovery order, and a case that was seemed very unwinnable all of a sudden became very winnable based upon what is it that the firm on the other side didn't want to produce. Conversely, case was very defendable, but I didn't have any documents. It was a case that my client had, my client had acquired through a merger. Couldn't produce documents to prove up one particular transaction, and that failure to have that document sunk a case, which was otherwise very winnable based upon the weight of the evidence. So all these things, come into play when you have an arbitration, because good, bad, or indifferent, it's been my experience that arbitration panels hold the brokerage community to a very exacting standard of care when it comes to documents and following procedures. Now, whether or not they should or they shouldn't, I mean, reasonable people can agree to disagree, but at the end of the day, documents and preserving documents becomes a huge issue in almost any sort of situation I come into.
So Lillian, you mind if I just throw one little war story in here? And the reason why this particular example keeps coming to mind is because it touches on a number of things that we've been talking about for the last 30 minutes already. So this particular case involved a number of alternative investments that were purchased over time. The concentration issue was kind of hovering around the firm's WSPs. The WSPs didn't have necessarily a hard ceiling on what percentage of net worth should be allocated to alternatives. It actually gave the firm some discretion in setting that threshold or that ceiling. And we could talk about that later. I'm not a big fan of that necessarily either. But in any event, this particular case, the rep 8 years later had no recollection of information that was disclosed on this particular suitability form. He thought that his licensed sales assistant would have completed it. So it wasn't a pre-populated form. But on the other hand, he was telling me, I didn't necessarily fill this out. My sales assistant filled it out. And the net worth information was markedly different than every other piece of paper we had in the file, to the tune of close to $1 million. And what was written on this form was that the claimant, had just received an inheritance from mom. And that's why the net worth information is different. And that's why there's no concentration issues. But lo and behold, 4 or 5 years later, mom's actually still alive. There was never an inheritance. And all of a sudden, a case where there were, I'll just say, very little to no NOPs, which could have been, perhaps should have been, a great candidate to try. We talked about this a little before getting on this call. So many of these claimants' lawyers these days are bringing cases without really vetting them, where they don't necessarily have damages, where they are not doing a ton of discovery before trying to get the case resolved. Clients are having a hard time figuring out and deciding what cases are we going to try to set the example. This could have been one of those cases, but for perhaps 8 words on a suitability form for one transaction. And it gets back to, should this have been drilled down on by the supervisor at the time it came through? Should we be allowing the sales assistant to complete this for the claimant to sign ultimately? Whose responsibility is it? And in any event, it made defending a case which was probably quite defensible, but for this one fact, a case that we had to overpay on. And it's unfortunate.
And, I suspect that you're going to have a lot of communication recorded, issues on a go-forward basis, because so many advisors and reps are communicating with their clients via Zoom, social media, texting, messaging. How do you capture all of those communications, and how do you document them clearly so that you can use those communications when you're defending yourself? Should they even be allowed to text?
I'll take a stab at this. I mean, read the Wall Street Journal recently. Wall Street got tuned up something fierce for having their associates do company business on non-approved systems. And what I thought was interesting is that I haven't seen one sort of indication that the comms themselves, the content of those comms was inappropriate. These have all been record keeping violations. And if we think that this, the 1.8 billion that hit some of the larger firms on the street is the end of the story, no, I've got it on information from some of my colleagues in the industry that this query is trickling down. So to your question, first and foremost, if your associates are doing business, they better be doing on approved systems that are being appropriately captured in accordance with record keeping requirements. Full stop. There is no exception. There's no, oh well, we're only on Twitter, DMing each other on Twitter because of whatever. It's on the email, whatever is it you're approving, whatever is it you're capturing, it's got to be there. Because for among other reasons, Amir, Derek, and I would like to see, as fulsome as record as possible when it comes to it, because sometimes these battles devolve into discovery fights, which have really nothing to do with the merits of the underlying case. But more importantly, the regulators have their antenna up on this particular issue, and we can't ignore that fact at all.
But are the broker dealers and the RIAs responsible for doing periodic checks, doing periodic forensics to discover whether or not any of their advisors or reps are communicating in an inappropriate manner or on systems that they should not be communicating on?
I think most firms, just as a matter of practice, already have very strict guidelines in their rep manuals as to what is and is not a permissible communication. The problem with FINRA and the SEC, and I know that one of the participants here is Howard Davis, and he can verify this, and as can Derek, and as can Ryan as a former regulator, is that there isn't a regulation necessarily on the books for every specific conduct. Regulations and standards are established through enforcement actions, and often it's the most egregious fact pattern that forms the basis for regulatory action that then results in the standard of care. So I don't know if it's realistic for a firm with, let's say, 1,000 registered representatives to audit LinkedIn or to audit text or to audit Facebook posts. That is probably, as a defense attorney that does regulatory work, I would say that goes beyond reasonable supervision. And I often say this: the standard is not to be omniscient; it's to be reasonable. And you're not always going to catch every stupid act committed by a broker, including a dumb post on LinkedIn or whatever it is. I do think that it is a good idea for firms at annual compliance reviews or in annual compliance meetings or branch office audits to emphasize that in 2022, we are in a world in which communications are taking place on social media platforms. And that you, as a registered professional, need to understand that whatever you say electronically, it's the same thing I tell my kids. There's going to be a record of it. It will not be forgotten. Be smart. So if you don't want mom and dad to see it, I don't want to see it on Snapchat. I don't want to see it on Instagram. I don't want to see it on Facebook. If you don't want your OSJ to see it, don't do it. Full stop. Don't think you're being cute by half by putting it on LinkedIn or texting your client or, communicating through a Gmail. That will evidence that you're not compliant with firms' policies and procedures, and B, that you're probably up to no good. And it's a very, very good idea that at least on an annual basis, and I think hopefully, Derek and Ryan would agree with this, that we want to see a broker-dealer reminding the registered representatives of their obligations in this regard. And that obviously applies to 40 Act or RIA firms, any registered RIA firms, either with the state or the SEC. Same thing. Just be smart about it. Be adults and follow our guidelines. They exist for your protection and ours.
And that goes right
Agreed.
into good
Absolutely agreed.
And
well, before we go, I want to add to that because I think Amir's spot on. In fact, if you're not covering this topic in your annual compliance meeting, Speaking only for myself, you probably should. I know I am here at the end of this month with one of my clients, but I'll also add, there's also things you can do on your usual comms. For example, I have a client who uses email surveillance tool. I added as flags now the things like text me, DM me, direct message me, things that you would see that, okay, we're on our approved comm channel, but now we're specifically taking it to an unapproved channels. And so that's what I'm looking for as a CCO. So I think that in addition to what Mir offered, you maybe tuning up what your current art in terms of the surveillances might be a good thing to do, because I think what ultimately the regulators are going to want to see is some sort of measure in this regard. Attestations are great, training are great, but they're probably going to see a little bit more. So anything you can, a firm can do to enhance what they're doing now and their communication surveillance, such as what I described, would be, I think, a good step.
Really good point, Ryan. Thank you. And we can continue with have good procedures and follow them, because that is a good procedure that you just gave us, and follow it. So what else can you add to that?
Well, putting on my former regulator hat, I ran my own investigations, and I supervised those who were conducting investigations. And oftentimes, and everyone will start nodding at the screen in front of them right now, is that when they've had an inquiry, oftentimes, if not in the first document production, it's going to be in the second. You give me your procedures with respect to whatever's that they're looking at. And so having procedures that are more than aspirational, and I can say I saw quite a few policy suites in my time where it was a great horn book on what, for example, what Reg D says, but it was very short on what to do about it. The more that a firm can bring specificity as to what is expected out of their associates to discharge whatever duty, the better off they're going to be. Now, of course, the flip side of that is that there's an art to it, because you don't want to paint people into a corner, because in setting up a mousetrap that is just unattainable, because it's worse to have a policy and a procedure that you do not follow or cannot follow than to have none whatsoever. So, spending some time, again, maybe another hygiene exercise is to look at the procedures with a critical eye and is this something we can actually act upon? And if so, is it something that you can reasonably discharge? And I think, even going through that exercise is a worthwhile thing, in addition to everything else, of course, that the regulators are wanting to, firms to do nowadays.
So
Yeah, and Lillian, if I could just apologize for interrupting you, add to that. What I have found in trying cases over the years are the most effective claimants lawyers. They are grilling the supervisor and the compliance witnesses on the WSPs. So in my opinion, I think that an effective claimants lawyer can take a case that may have some warts that otherwise should be defensible, and turn it upside down and basically grill your supervisor, grill your compliance person on, whatever sections of the WSPs they've obtained in discovery. They could demonstrate that this, that, and the other thing is just not happening per the WSPs. It just impacts credibility for a fact finder, and it makes whatever arguments you're bringing in defense of the case that much more difficult to maintain. And so it's one thing to have them. It's another thing to make sure that they are enforced. And then getting back to the documentation part of this, it's another thing, 3, 4, 5 years down the road to have documentation that, yeah, we did do X, Y, and Z. Not that this was the practice. I'm sure it happened, but no one's around anymore who might even remember that it occurred. Here's the piece of paper that demonstrates it happened.
Well, I'm glad you brought WSPs up, Derek, because I know that every once in a while exceptions are made to certain WSP rules. And what is your opinion as to how those exceptions should be documented, and under what circumstances should exceptions be made?
Yeah, that's a great question. And frankly, for me, it's a hard question to answer. And I brought this up earlier. I've got one particular client who sells alternatives, but doesn't necessarily have a hard ceiling on how much of the liquid net worth or the net worth or the investable assets should be comprised of alternative investments. And so there's some inherent discretion there that's given to the rep and to the supervisor, which frankly, I think puts everyone in a difficult position to explain that down the road. But let's say that a firm's got, and again, I'm using alternatives and concentration because I think it's an issue that we're seeing a lot these days in customer arbitrations. Let's say you got a firm that puts the ceiling at 20%, but says essentially exceptions can be made on a case-by-case basis, right? So that might be a case where you've got, for instance, a really high net worth claimant who's got $20 million in real estate sitting outside of the firm, has the ability to withstand risk, understands and appreciates the risk that these types of investments may bring to the table, and essentially makes an informed decision. This is what I want to do with my money. You are my broker. This is what I am instructing you to do. So I'm not saying that it's never the case that it should be allowed. There certainly may be situations where it can be allowed, but again, documentation, right? So if the rep puts this through and the supervisor catches that it's over that 20% ceiling, and there is an email exchange by the review team to the rep, hey, wait a minute, what's going on here? Make sure there's a response, make sure there's a call, make sure there's a note to the file. Hey, we had this conversation with this claimant at the time, and this is what was discussed, and this is what was decided. And then after the fact, and again, this gets back to those negative consent letters, after the fact, send out that letter and say, this is what our WSPs say. You've asked us to do this. We agree that this was something we will do for the following reasons. And just make sure that that's documented in the file so that, if by chance 4 years from now, the firm files bankruptcy and the investment is completely useless, and an ambulance chaser finds this particular claimant and brings a case, someone can explain what happened.
Well, thank you for that, Derek. That's wonderful. We're going to move on. Do not send answers or information to regulators that beg additional questions. You want to comment on that, Ryan?
Yeah, we all get requests from regulators from time to time, and some of the requests are spot on, others are a little bit fuzzy, but you can't help that. You can only control your response. And I've seen this throughout my career where, not necessarily my clients, but rather when I was a CCO for a clearing firm, I would get queries from state regulators who are doing exams of the firms that are custodying assets on the platform. And you can tell just by the tone and tenor of the letters coming to the custodian that, they're not quite understanding what is it they're being fed. And that's just from where I sit, the worst possible place to be in, because you're caught in this endless death spiral of call and response with the regulators, and we're still it affords them an opportunity to jump to the wrong conclusion, either because they're misinformed or just whatever that you said was otherwise unclear to them. So I've always had a fundamental axiom is if you're going to send something over the transom to the regulator, make sure that is you do the best job you can to make sure it's as clearly articulating your position as possible, because the last thing you want to do is just end up in either the one or two worlds, the endless death spiral of call and response, or worse still, the regulators jump to the wrong conclusion about what you're doing because you haven't made yourself clear.
Thank you. Any further comments on that? Try to get the small stuff right. Amir?
No, I think that's exactly right. I think, I think from a regulatory perspective and in the sort of the climate we're in, the more you adhere, the more you demonstrate, I think, to regulators that you have there was this catchphrase a few years ago and it sort of dissipated, culture of compliance. And I think the way you sort of demonstrate that is by sweating the small stuff, being ahead of it and showing that you're proactive, not reactive. That we now, a broker dealer that for a while stopped the sale of alternatives, is now going back into that space and is really making a concerted effort to understand the products they're selling, the issuers, the getting an understanding. I mean, here's an example of sweating the small stuff. Sometimes, the defense will, in a lot of these cases, well, we got third-party due diligence. Well, who's doing due diligence on the due diligence providers? Mm-hmm. And this is not to disparage the folks that do due diligence. We all know them. Everybody on this call knows them. We've met with them. They've testified for us. We've taken their depositions. We know who these people are. But like any professional, they do make mistakes. Lawyers make mistakes, and they're not infallible. So this idea that you got third-party due diligence and that's going to be a defense to a product that had real red flags is going to butt up to limitations if you didn't perform some maybe requisite due diligence on the due diligence provider. And that's one of the client that I'm talking about right now is struggling with that. Like in approving a product, what are we learning about their track record, that these third-party due diligence providers with respect to their track record in approving product? Why did you miss this product? Why did you miss that there were problems with this one product? That's a very discrete example of sweating the small stuff. Be cautious by half, err on the side of caution. We understand that your competitors are offering these products, and that makes you maybe competitively disadvantaged, puts you at a competitive disadvantage. But you could be at a long-term advantage if you're not willy-nilly approving a lot of alternatives that other firms are rejecting. Be smart, be slow, and be cautious, and be ahead of terms and be ahead of trends. The SEC advertises its regulatory priorities. I mean, think about that. I mean, think about what a advantage that could be if you see that and you say, you know what, we're going to take 4 of these things and we're going to have meetings about these 4 things. Because we know the SEC is looking at this. This is a regulatory priority. FINRA does the same thing. They're doing that, and you can demonstrate goodwill to the regulators. You can demonstrate that these things matter if you're forced to testify at a hearing. And to Derek's very good point, it's the chief compliance officer and the supervisors that are testifying. And it's really easy when we're doing a direct examination of our own chief compliance officer to ask a bunch of layup questions about how the firm stays ahead of these these trends and these hot button issues. And you do that by, the catchphrase for this presentation is sweating the small stuff. Just do it.
And that's a really great segue to, we have a question, and then we're going to get to our final comment here. But our friend Ellen Slip has asked, what is the panel seeing by way of claims in 2023? And are you expecting to see more Reg BI related matters? The decline in the market, is that going to increase the number of arbitrations that we expect to see? Are you seeing margin cases, more sophisticated alternative product cases? Ryan, why don't we start with you? What do you predict we're going to see more of in 2023?
I think certainly Reg BI is going to be more of a focus, and at some weird twisted level, I think I almost welcome it to get some clarity as to what the regulators are expecting. Because right now, the first case that FINRA brought when they tuned up a individual person under Reg BI was a case that had such bad facts. I mean, it would have been an issue for this person under any standard, the suitability standard, or even going back just, the old Article 3, FINRA NAC rule standard. So I think that's going to be an issue. I think anything that FINRA has identified in its regulatory notices, and I'm building on, I think Amir's points are well put. I would add to that, anything that FINRA puts into a regulatory notice or the SEC's Division of Exams puts into a risk alert is going to be, fodder in the coming year. For example, with vendors, the SEC just put out a rule about vetting your vendors. Whether or not it comes to fruition, who knows? But this is foretold from where I sit by the risk alert early this year about examining vendors for mistakenly ingesting material non-public information and inquiring about insider trading. So I think all those things are going to be brought to bear because the regulators are telling us that they're going to bring them to bear. So keeping an eye on those things is certainly going to be top of the order. Now, how you react to them, of course, that goes into your risk-based calculus, but certainly paying attention to those hot button issues we're going to see more of that, I think, in 23.
Derek, what are your thoughts?
Yeah, so as a firm, we are still seeing a ton of alternative investment cases. We've seen a handful of, I'll just call it market-related cases where, somebody had perhaps a concentrated position lost some money, someone moved to the sideline. I think we've seen just a small handful of Reg BI cases, but again, frankly, what's driving the caseload are still alternatives and product failure cases.
Right, due diligence related matters.
Yeah.
The whole other hour or two.
Well, and that's an interesting point, and we're almost at the end of this. I think the claimants lawyers would like to paint these as due diligence cases. I'd like to paint them as cherry picking cases because they're picking one alt out of a portfolio of 5. The other 4 may have done well, and they may have a well-balanced portfolio with the other 80%. So now I'm having conversations with carriers and clients. Hey, we need to do a P&L on the whole portfolio. We need to do a P&L on all the alts, because these guys want to get away with just cherry picking that one alt that filed bankruptcy. So that's in any event.
Interesting point. Amir,
Yeah.
what are your thoughts?
I echo what Ryan and Derek are saying. I mean, the vast majority of the cases are still product related. You know, one of the Piava attorneys essentially has advertised now, and I think he issued a press release, the former president of Piava, that they are now going to routinely include Reg BI as an allegation or a cause of action in their pleadings. I think to Ryan's point, you know, Reg BI, there's not case law on it. There's obviously, everybody's aware of the SEC action that was filed against Western International, and that's going to be, I think, instructive in terms of interpreting what Reg BI means. It's an interesting case that they chose, and an interesting strategy that Western is implementing in that case. But I think you are going to see Reg BI tacked onto it because it gets you closer to that fiduciary standard, which again, it's like sort of, you know, being half pregnant. It would have been easier if they had just filed the fiduciary rule. Everybody knows what that means, and now everybody's scratching their head like, what does Reg BI really mean? But we should, you know, as practitioners and as, you know, broker dealers, we should be prepared for those cases, and to understand that you need to you know, fix your policies and procedures with respect to that and start documenting that. I do think if there's more market volatility, you're probably going to see more products fail. If we're really sort of entering, you know, there's been talk that a lot of these structured notes are going to, you know, they have resets within them, and those parameters are going to be hit, and you know, people are predicting that there's going to be failures in structured notes. I could see some of those cases being filed. And to sort of dispense with the elephant in the room, I think that you know, we are seeing waves of litigation relating to GWG. No,
Absolutely.
if we want to be very specific about it, GWG is resulting in, you know, a tsunami of litigation.
Well, we understand the claimants' attorneys have the complete client list, so they're going after everybody.
They are, yeah.
They are. Hey, we're going to finalize this wonderful presentation with a question. Know when to ask for assistance. So when do you ask for assistance? And it's assistance from outside attorneys, perhaps. How about your E&O carrier? Derek, you want to comment on that?
Yeah, so my thought on both is early on. You know, with respect to your carrier, I've got some regulatory issues going on for clients now, where client didn't think that there was coverage under his policy, and it turns out that there was. It wasn't just an audit he was dealing with. It was almost, I'll characterize it as an audit plus, and you know, I think it makes sense to reach out to the carrier early on to determine what coverages are available given whatever the situation is. And then with respect to counsel, you know, same answer. So many of these issues that Amir and Ryan are dealing with have a regulatory component that kind of overlays all these different customer cases, excuse me. And firms may be thinking along those lines, but sometimes there's so much compartmentalization that you may not be. So if you send a response off to a regulator that might impact, you know, a case I'm defending, I'd like to have at least some forewarning that that's out there before I discover it, you know, 8 months down the road, in getting documents from clients, and then all of a sudden realizing I have to produce it in discovery in this case. So I think it's important to reach out to, you know, basically your resources early on.
I agree with that. And there are a number of E&O policies now that they do have a sublimit of liability to respond to requests for subpoena documents as well as statements on the record.
Right.
And any regulatory matters. Typically, it's a small sublimit of liability, but it's enough to get you an attorney and at least to respond to those matters. D&O policies tend to have more robust regulatory coverage under their policies. So, in the past, independent broker dealers were not buying D&O insurance. They are now, and there is value to buying D&O insurance, particularly for that regulatory coverage. Amir, Ryan, you want to add any closing remarks?
No, I agree with what Derek said. I mean, it's, if you, have a set, there isn't a case we have now, I'm really not exaggerating, where I don't get a request for exchanges between my client and a regulator. I object, we put up, as strenuous, vigorous, persuasive arguments, and every now and then we get an order that says we want to see it all. I understand you have to straddle the line, and I think Ryan has spoken to this and has Derek, that you want to be cooperative with the regulators. You want to create the impression that you're being forthright and forthcoming with them. But imagine 3 arbitrators looking at every communication that you sent to FINRA, and imagine what the impact of some of those communications are 9 months down the line in front of an arbitration panel where you may have inadvertently made an admission that you wish you hadn't made. And for that reason, having counsel retained early, I think, is advisable, because we won't ever tell you exactly what to say, but we will give you a perspective on the impact of that on litigation.
I think this point's well said, and I'll offer just this point. If you're asking yourself the question, should I have a lawyer for this? The answer is almost always going to be yes. Because if you're asking yourself that question, that's that inflection point where you're hitting upon the things that Derek and Amir just offered to you. So I'll end with that.
And start with your carrier first, because if you do have coverage for some regulatory matters, then they will retain the counsel for you and will save you that bit of a headache. Well, if we have any questions, let's open it up to some questions for this wonderful panel today. If not, I want to thank you all for participating with us today. Derek, Amir, Ryan, thank you so much for sharing your expertise with us. And if anybody would like to follow up, I'll be sending out copies of our notes for the presentation with all of our contact information. So thank you all, and enjoy the rest of November.
Great, thank you.
Bye-bye.
Thank you.
Bye.
Be well.